All right, and that's what I'm going to call now because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, Mr. DeBus, you want to start your video? We are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBoos with Jared Regier for the state, Mr. DeBoos in person.
You can sense the tension instantly. This isn't just another traffic case. It's a full-blown sovereign citizen standoff in the making. Anthony Deo insists on representing himself, armed with confidence but no grasp of courtroom procedure. Every word he utters signals trouble ahead, and the judge, calm but cautious, already knows he's in for a long, exhausting battle of patience.
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that...
And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
And here's where the circus truly begins. Deo demands the judge recite his oath of office, as if saying it aloud will somehow make the entire court vanish. It's textbook sovereign citizen theater, the illusion that authority only exists through personal consent. But the judge, composed and unshaken, refuses to entertain the delusion, cutting through the nonsense with quiet, unwavering authority.
Subsequently, now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a...
Like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a... Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check, I don't think, Mr. DeBoos, that you have...
Watch as the courtroom descends into pure absurdity. Deo insists he never entered a plea, accusing the judge of speaking on his behalf. But here's the legal reality. When a defendant refuses to respond, the court enters a not guilty plea to move forward. Justice doesn't pause for theatrics, and shouting, "I don't consent," doesn't freeze the law in place.
That he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issue or trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 amendment.
In light of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive.
You don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay.
And Your Honor, I would note that pursuant to the information filed with the court in August, this case does appear to include 3 counts, 2 Class Bs, and an unclassified non-person misdemeanor. While it would appear that in this particular instance, subsection 2, pursuant to KSA 216602, quote, for purposes of sentencing, the following classes of misdemeanors and the punishment and the terms of confinement associated for each class are established. Class B, the sentence for which shall be a definite term of confinement, county jail, which shall be fixed by the court and shall not exceed 6 months. So, given that my understanding is that neither a plea nor sentencing recommendations have been submitted to the court in this matter, it would appear that at least the issue raised by standby counsel is somewhat academic.
So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory cite?
This is where fantasy collides headfirst with reality. Deo claims to be just a common man, lost in legal jargon, yet he insists on debating constitutional rights he clearly doesn't understand. His standby counsel has to step in just to keep him from sinking deeper into confusion. Exactly what the judge predicted would happen.
Your case law cites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now, before you go to that, now, Mr. DeBoost, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoost, the point is you do have the right to represent yourself, and you've told me.
The judge finally draws the line. If Dale wants to represent himself, he must follow the same rules as any licensed attorney. No loopholes, no magic words, no corporate fiction, fairy tales. His refusal to accept that truth makes the scene both frustrating and revealing. He's trapped inside a system he rejects, yet still bound by every rule of it.
Represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you, and do you not want to have his legal assistance to let him represent you?
Do not wish to be represented by a attorney whose duty first is to the courts and not to their clients. And
despite all the chaos, the judge grants Deo a continuance until October, a display of remarkable patience. Yet, in true sovereign citizen fashion, Deo calls his own bond unlawful, even after getting exactly what he requested. It's the perfect irony, a man demanding freedom from the very system showing him grace.
if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barrick was an unlawful arrest
All right,
for
well, we're not going on.
22-2401.
We're not going down that
enforcement
path
officer.
right now, sir. We're not going down that path right now. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBooth?
May I ask that there be an extension so that way I may fully research the procedures, the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic.
Cases like this expose the clash between personal delusion and legal reality. Deo's defiance isn't about justice, it's about control. Yet through it all, the judge's steady composure proves a timeless truth. Reason will always outlast noise.
Trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and
Of 2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be 30th, 2024. Do you have any objections to?
No objections. Let me write those dates down. You said September what?
The pretrial is September 30th, 2024 at 9 a.m. And the jury trial starts at 9 a.m. October 2nd and 3rd.
Both of those dates?
Both of those dates.
Okay. I would like to point out that the bond and bail I made on this arrest is an unlawful bond, considering that the arrest was unlawful itself.
Looks like Judge Crum set your bond on August 18th, 2023 at $2,500 cash or surety, and that will be maintained so long as, sir, you appear at every date and time you're requesting. Anything else, Mr. Regier, we need to take up on this matter?
Your Honor, if court is granting the defendant's request for continuance, I would respectfully have it noted for the record that this case at the next hearing will be over a year in age, as I understand it. So the state is not in favor of this continuance. So I would respectfully